Welcome to Kellum Law Firm's YouTube channel. If you've been involved in an accident, one of the first things an insurance adjuster may ask you for is a recorded statement. It often sounds simple, harmless even. They may say, "We just need to get your side of the story," or "This will help us process the claim faster," or "It's just routine." But here's what many people don't realize. A recorded statement is not a casual conversation. It is a formal, documented interview, and it can significantly affect your injury claim. Let me explain why. When you give a recorded statement, everything you say is preserved. Your exact words, your tone, your phrasing. If your case later becomes disputed, that recording may be reviewed repeatedly, sometimes months or even years later. The adjuster is trained to ask questions in ways that may seem conversational, but are carefully structured. For example, "How are you feeling today?" Most people answer, "I'm okay," or "I'm doing all right." But if you're pursuing an injury claim, that answer can later be interpreted as evidence that you weren't seriously hurt. Or you may be asked, "Is it possible you didn't see the other vehicle before impact?" Even a hesitant response can be framed as uncertainty about fault. Another issue is timing. In the hours or days after an accident, you may not fully understand your injuries. Some conditions, like soft tissue injuries, concussions, or internal injuries, may not present immediate symptoms. If you speculate during a recorded statement and later your medical condition worsens, the insurance company may point back to that early recording and argue inconsistency. And inconsistency is something insurers focus on heavily. Now, many people ask, is a recorded statement the same thing as a deposition? The answer is no, but they can both impact your case. A deposition happens after a lawsuit has been filed. It is part of the formal legal process. You are under oath. There are attorneys present. A court reporter records everything. Your lawyer is there to object to improper questions and to protect you during the process. A recorded statement, on the other hand, typically happens before a lawsuit is filed. It is usually conducted by an insurance adjuster. You are not in a courtroom. There is no judge. And most importantly, many people give recorded statements without legal guidance. That is what makes them risky, because while a recorded statement is not a deposition, it can still be used later in litigation. If a lawsuit is filed, that earlier recording may be compared against your deposition testimony. If there are differences, the insurance company may argue that your story changed. It's also important to understand this. You are generally not required to provide a recorded statement to the other driver's insurance company. Your own insurance policy may require cooperation, but that does not mean you must answer every question immediately or without preparation and legal representation. This is where people unintentionally hurt their own claims. They assume cooperation means compliance without caution. In reality, protecting your claim means understanding what is being asked, why it is being asked, and how your words could be used later. At our firm, when someone contacts us before giving a recorded statement, we help them understand what to expect. Sometimes we handle communication directly. Sometimes we guide them on how to respond appropriately. The goal is not to avoid cooperation. It is to avoid unnecessary risk. Insurance companies are businesses. Their objective is to evaluate liability and limit financial exposure. That is not personal. It is structural. But you should not walk into a recorded interview without understanding that reality. If you've already given a recorded statement and are now concerned about what was said, that does not automatically mean your case is lost. Context matters. Evidence matters. Medical documentation matters. But if you have not yet provided one, pause before you do. Ask whether it is required. Ask whether it is wise. Ask whether you should speak with counsel first. A short conversation at the right time can prevent significant problems later. If you've been asked to give a recorded statement after an accident in North Carolina and you're unsure how to proceed, contact us. We can review your situation and help you make an informed decision. Thank you for watching. If this video was helpful, please like and subscribe to our channel for more information about protecting your rights. And if you need assistance, visit KellumLawFirm.com to schedule a consultation. We're with you all the way.